So what we are starting today, that is Foreign Trade Development and Regulation Act. Foreign trade, right? So every word requires little understanding. So what is foreign trade? Certainly we understand what is the meaning of foreign trade. This is certainly import and export, right? But the difference lies here that whatever we have studied under the Customs Act or the Customs Tariff Act, that relates only and only to goods. But FTDRA relates to goods and services both. Goods and services both. So this is much broader in coverage as compared to the Customs Act. Because Customs Act deals with only import and export of goods only. Services are not covered under the Customs Act. But this one deals with services also. Okay. Then the next is development. So development, certainly we are talking about increase or growth. Increase or growth. Now, what is intended to be increased? Certainly nobody intends to increase the imports. So imports are required to be facilitated, right? So import, we are not saying that reduce the import, not at all. That cannot be the intention. That cannot be the intention, that reduce the import. No. We already have specific provisions under section 25A and 25B where we invite the goods for processing in India and we send the goods outside India for processing. So that activity will always go on. So if you have supposed to increase the export, import will automatically increase. So when the imports are increasing, those are required to be regulated, right? Those are facilitated and regulated. So as far as exports are concerned, we talk about promotion or increase of export, right? As far as imports are concerned, neither we talk about increase nor we talk about decrease. We talk about facilitating. See the wordings used in the act. In relation to export, we are using the word promotion or increase. In relation to import, we are using the word facilitating. And both the activities, whether import or export, are required to be regulated. Nothing is left free. Neither 100% export is free nor 100% import is free. Everything is regulated, right? And to a certain extent, we already know the provisions under the Customs Act that certain goods are prohibited, certain goods are regulated, and the other laws are also there. Okay, so regulation means a direction or the guidelines or the procedure in relation to import and export. So procedures are there in relation to export as well as import both. So in relation to export, what is the wordings? Promotion or increase. In relation to import, this is facilitating. We are not talking about reduction of import. Right. Just think of if by chance if we put a condition that imports have to be reduced, what will happen? If we reduce the import, quite possible certain industries in India are not in a position to function. Not today's news itself. Apple phone, iPhone is being assembled in India, but right now assembly line has stopped the functioning because the cards are not available, which comes from Taiwan. So just imagine a situation that it is a different situation, that it is not available as of today. But by chance, if you try to stop the import of those chips, what happens? Your another industry gets stopped functioning. Okay, so there is no intention to either reduce or prohibit the imports. Okay, so that is required to be facilitated. And this is the act which mainly talks about two things which are relevant for us. One is DGFT, appointment of DGFT. Another is foreign trade policy. And next is penalties. Not everything is relevant in the act, but three provisions are important for us. Right? You can add one more also here. It is IEC. So four topics are relevant in the act. One is appointment of DGFT. Another is allotment of the importer-exporter code number, then suspension, then cancellation, then a special license automatically get associated. Then the foreign trade policy is framed by virtue of the authorization given to the central government under this act. And when there is a violation of the provisions of this act or the foreign trade policy, then penalties are applicable. So four topics are important in this act. Appointment of DGFT and his role. Number two, allotment of importer-exporter code number and related provisions. Number three, the foreign trade policy, framing of the foreign trade policy and the power to amend or etc. And then penalties for violation of the provisions of this act or under the foreign trade policy. Okay. Now, this is the material already sent to all of you. Right. So this is already with you, the Foreign Trade Development and Regulation Act. As such, this is the entire list of the sections applicable. But as I told you, what is relevant is that few definitions are going to be important for us. We are going to refer the definitions. Then section 5 authorizes the central government to make the foreign trade policy. Then section 6 talks about appointment of the DGFT and his functions. Then importer-exporter code number is allotted under section 7. Then suspension and issue of license. There is 7, 8, 9. These three things have to be done together. In addition to that, the quantitative restriction, this chapter is related to safeguard measures, which are referred under section 8B of the Customs Tariff Act. So quantitative restrictions, or you can say the tariff quota allotted. So similar provisions are you are going to see under section 9A. And then power to search, seizure, etc. are given. Then penalties are here. Penalty, confiscation, not to interfere with other things. Okay. So these are main provisions. Then appeal can be filed herein. That is the last provision to be discussed. So not many provisions. So first of all, coming to the object of the act. What is this is called? What are the first lines are referred in the act?
Preambles. Preamble.
Preamble or object of the act. Either preamble or object. So what it says, an act to provide for development and regulation of foreign trade by facilitating imports and augmenting means growth or increase or development of exports from India and for matters connected therewith or incidental thereto. So this is for regulating the foreign development and regulation of foreign trade. And what is the main thing is facilitating imports and augmenting exports. So while interpreting the law, or you can say this act or the foreign trade policy, these words are going to be very, very crucial. That imports are facilitated, exports are augmented, promoted, increased, growth. Okay. So any provision which is required to be interpreted even before the appellate authority is also going to consider the same wordings. That imports are required to be facilitated and exports are required to be augmented. So unless something is absolutely against the interest of the domestic industry or the interest of the nation, nothing is prohibited in law. Nothing is prohibited. right? Because everywhere we are talking about imports facilitated, exports augmented. So there is nothing like prohibition. So prohibition comes into picture only when something is contrary to law. Or when it is contrary to law, it is against public interest or against interest of the nation. Then that becomes contrary to law. So there are provisions for prohibition, but in general, prohibition is not the object of this law. That is not the object. Okay. So whenever you are interpreting either this act or the foreign trade policy, the interpretation has to be based on these two words. Okay. Now, in section 2, every word I am not going to explain because everything is already known to you. What is important, only that much I am going to discuss. What is important export? Already known to you, but this is in relation to goods. And this is in relation to services and technology. So two clauses mainly. So first is goods. So in relation to the goods, so bringing into or taking out of India any goods by land, sea or air. This definition is different as compared to Customs Act. Right. It is simply talking about taking the goods out of India. It doesn't talk about destination being outside India. That is a technical difference for discussion. Actually, there is no difference. Okay, because without customs, no import export. So in any case, we have to keep in mind the definition given under customs also. This is only a technical difference. And this is clause number 2. This is in relation to services or technology. So whether this is given from outside India, so this is from the territory of another country into the territory of India, and there is second clause that is supplying service or technology from India to a place or any other country. Other clauses are only some more explanations. So you're not supposed to remember this definition. याद करने की आपको आवश्यकता नहीं है. Okay. Importer exporter code number in the code number allotted under section 7. License. When the license is required, license means license to import or export and includes a custom clearance permit and other permissions issued and granted under this act. So this act will provide for one specific license, and that license is called as a special license. And why a special license is required? By chance, if somebody's IEC code is cancelled, then he can complete the existing transactions of which are pending only by virtue of a special license. So one license is prescribed under this act also. There may be licenses as per other laws also. But as far as this act is concerned, this act provides for license, special license. So when the special license is required, listen carefully. So somebody's IEC code is cancelled. If it is suspended, a special license is not issued. It is issued only when it is cancelled. So when it is cancelled, a special license is issued only for completing the existing transactions or pending issues. Okay. So license. Services, whatever is made, whatever services are made available. So this act deals with the goods and services both. So that distinction I have already made in the beginning itself. That Foreign Trade Development Regulation Act as well as Foreign Trade Policy deals not only with the goods. So goods plus services both are covered under these laws. Now this is a relevant definition which will be important for you to understand. Right? Chances of question being there are almost nil, but important. This is specified goods or services or technology. Specified goods or services or technology. So what is called a technology? Now read the definition. What is called technology? This is means the information other than information in the public domain that is capable of being development, production, or development carrying out industrial commercial activity, that is referred as a technology. So that is basically an information that can be used for different purposes. So here we are talking about specified goods or services or technology. Okay, so technology means only information. Services mean the activity being done. Goods means these are some tangible items are being either imported or exported. So this is specified goods or service or technology means goods or service or technology, the export, import, transfer, retransfer, transit, transshipment, which is prohibited or restricted. But why? Reason is also there. First of all, this may be either goods or technology or services. And The either export or import or transfer or retransfer or transit or transshipment of that is either prohibited or restricted. Prohibited means not allowed. Restricted means subject to certain conditions. But why? This is because of imposition of condition, the grounds of their being pertinent or relevant to India as a nuclear weapon state. So these are the either goods or services or technology which can be used in connection with the nuclear weapons, which can be used directly or indirectly in connection with the nuclear weapons, or you can say weapons of mass destruction. So those are called specified goods or services or technology for the purpose of this act. Now, you know specified goods under the Customs Act. Which are the specified goods under the Customs Act?
11I, sir, that are
Arms
specified under
ammunitions.
11.
Under section 11H to 11M, those are the goods which are likely to be smuggled out of India. And, right. That is altogether different concept. When we talk about Foreign Trade Development Regulation Act, specified goods or services or technology means the goods or service or technology that either import or export or transshipment or retransfer thereof is either prohibited or restricted because those are related to nuclear weapons. One that can be used for or in connection with the nuclear weapons, or you can say weapons of mass destruction. So that is referred as specified goods or services. Technology, okay. So those are the definitions which are important. So under section 3, now till now what you have understood in this act? अभी तक आपने क्या-क्या देखा? What is the purpose of this act? What is the object of this act?
Development and regulation of foreign trade.
Development
By
and
Promotion of-
regulation
promotion of
of
export
foreign
and-
trade.
Yes, first make a body, next make the regular policy, and then IC, and then the penalty.
No, those are important provisions. I said, what is the purpose of this act?
To facilitate the import and augmenting the export.
Export.
Right? So that is the preamble of the act. Now, what important we referred, we talked about that this act deals with the goods as well as services both. For import export, the definition is slightly different as compared to what is given under the Customs Act. Then the one important definition that we have talked about, that is specified goods or services or technology. So that is either goods or services or technology, the either for which the either import or export or transfer or retransfer or shipment, transshipment, etc. either prohibited or regulated. But why? Because of its being pertinent to
National security.
weapons. Right. So when it is a nuclear weapon, then certainly it is a matter of national security or national threat or international matter. Okay. So when something is related to nuclear weapons, then that will be referred as specified goods or services or technology. Okay. Now, under section 3, this says the central government may by order. Now, here it is not a notification. This is talking about the order. Published in the official gazette, make provision for the development regulation of foreign trade by facilitating import and increasing exports. So, uski zarurat hi nahi hai, simple, only one word is relevant in this because everything else is just a repetition of the object of the act. Then, the central government may also by order published in the official gazette make provision for prohibition, restricting, or otherwise regulating import or export of goods or services or technology. So what is to be read that I have already highlighted? Right. So government is having authority for regulating. So in regulation, that talks about facilitating plus increase plus prohibition plus restriction plus otherwise regulating everything. All the powers are vested in the central government. And later on, you are going to see that powers under section 3 of the central government are exercisable by central government itself. That will not be delegated. Otherwise, all other functions are delegated to the DGFT. But these functions are not delegated. Okay. And then, provided that the provisions of this subsection shall be applicable in case of import, export of service or technology only when the service or technology provider is availing benefits under the FTP or is dealing with the specified services or goods or specified technologies. So in this act, applicability of the act, applicability of the act, where does it apply? Goods, services and technology. In relation to goods, always applicable. In relation to services and technology, specified services, technology, or others. For specified services and technology, always applicable. For other services and technology, provisions of the act will be applicable only if the importer or exporter is willing to avail any facility under the foreign trade policy. If he doesn't want to avail any facility or any exemption or any incentive under the foreign trade policy, then provisions are not applicable. Right. So in relation to goods you want to import, export, FTP is always applicable. But when the provisions of the FTP are applicable in relation to services, only when importer or exporter is willing to avail any facility or any incentive under the foreign trade policy, or same this act also. So in case of other services and technology, right? So this is subject to prohibition or restriction only if importer or exporter is willing to avail any facility or incentive under FTP.
Sir, the only central government will determine these goods, these service and technology comes under specified, these comes under the others service and technology.
दोबारा बोलिए, आपकी आवाज ब्रेक हो गई.
Sir, only central government is competent to bifurcate this specified or other goods.
Yes.
Okay, sir.
All the powers are vested with the central government only. So this is applicability. Okay, so this applicability is not only of this act, this is also the applicability of the foreign trade policy. Okay, so here you can put a slash. That will help you to understand FTP also simultaneously. Okay. So where and how the act applies. So act applies in relation to import, export of goods always. When it comes to service and technology, if those are specified goods, specified service and technology, because specified goods are covered here. Right? When we say goods, so specified goods are also covered. Okay. Here we have specified technologies and non-specified technologies. So for specified, provisions are always applicable. Non-specified, subject to restrictions and prohibitions otherwise prescribed. Not applicable unless the importer exporter is willing to avail services. Right. So just for your reference, export of services is having a facility under the foreign trade policy that is called SEIS scheme. SEIS scheme. services export from India scheme. Earlier, there used to be MEIS and SEIS. Right. So MEIS has gone. SEIS continues. So SEIS provides for some incentives. So if the person is providing the services for which SEIS is available, then he is entitled for the incentives. And if he wants to avail the incentive, then provisions are applicable, otherwise not. Okay. Is this part clear? All goods to which any order under subsection 2 applies shall be deemed to be goods import export which have been prohibited under section 11 of the Customs Act, and the provisions of the Act shall apply accordingly. So wherever any such notification has been issued by the government, those will be treated as the prohibited goods for the purpose of Customs Act. And under section 11 of the Customs Act, you say either prohibition is under that law or under any other law. So those are prohibited goods. So this is a confirmation that under FTDRA also the central government is having a right to prohibit or restrict import or export of any of the goods or services, and those will also be considered as prohibited goods for the purpose of section 11 of the Customs Act. So that is just correlation. Okay, so even if you don't remember this, doesn't make any difference. कोई जरूरत नहीं उसको याद करने का भी आपको. तो actually यहाँ तक कुछ याद करने का है ही नहीं section में, it is only understanding. Now, without prejudice means what? Just say without prejudice to the anything contained in any other law, rules or regulation or notification or order.
Whatever is written contrary in any other law.
Without affecting.
Provisions will continue to be applicable. अगर यहाँ लिखते without notwithstanding anything contained in any other law, तो फिर मीनिंग वो हो जाता है कि साहब दूसरी जगह क्या लिखा है, forget that this is applicable. This is saying without prejudice means without affecting the applicability of any other law, rules or regulation or notification order. So means if there is any other law or rule or regulation or notification or order, that will continue to be applicable. नवीन जी क्या कंफ्यूजन हो गया?
कुछ नहीं सर.
Anyway, no permit or license shall be necessary for import export of any of the goods shall be prohibited on import export except as may be required under this act, rules or etc. So यहाँ पर कह रहे हैं कि साहब उस चीज को छोड़ दो कि यहाँ पर जो सबसेक्शन 2 में जो ऑर्डर इशू कर रखा हो, जहां पर प्रोहिबिशन रेस्ट्रिक्शन वगैरह हैं, उन चीजों को छोड़कर बाकी किसी भी चीज के लिए ना कोई लाइसेंस चाहिए, ना कोई परमिशन चाहिए, कुछ नहीं. सो फॉरेन ट्रेड पॉलिसी में यू आर गोइंग टू सी दैट इंपोर्ट एक्सपोर्ट ऑफ ऑल द आइटम्स आर फ्री except those which are prohibited or regulated. Okay, so what is the meaning of free import export? Okay, तो यहीं पर मैं लिखता हूं उसका मीनिंग. तो फॉरेन ट्रेड पॉलिसी में वापस से उस चीज को पढ़ेंगे. As per section 3, import export of goods and services unless prohibited or regulated under any law shall be free. Free means no license, etc. is required. So either license or permit or authorization, nothing is needed. Okay, but in the foreign trade policy, there are two specific schemes, or rather three schemes, which we talk about: advance authorization, duty-free import authorization, EPCG scheme. Then why those authorizations are required? Just a logical discussion. Here we are saying free. Then why those authorizations are required?
That is exemption from duty.
Exactly. So if you want to pay the duty, import the article, no authorization is needed, but you want to avail the exemptions for a specific, when you import the goods for a specific purpose, then those authorizations are needed. Otherwise, if you don't want to avail the facility under those schemes, import shall be free. Right. So when we say except unless prohibited or regulated, so under some law it is like for example NDPS, there the authorization is given to the pharmaceutical industries and laboratories for import of the articles which are otherwise prohibited. So those are regulated. So those who are having the license, they can import. Those who are not having license, they cannot import. So prima facie that is prohibited, but otherwise that is actually a regulated item. Okay, so unless prohibited or regulated under any law, इस चीज को underline कीजिएगा, under any law, not only this act, not only the customs act, under any law. So either customs act or foreign trade policy or no order issued under section 3 or under any other law, right? Import or export of the goods or services shall be free. Right now, here itself you can understand, you can correlate it. That what is about the import export of the specified goods and services? Not allowed, isn't it? So just an example here itself. And there is a long list of the articles which are prohibited, and that is in relation to nuclear waste. So that is not you are supposed to remember. आपको सिर्फ इतना पता होना चाहिए कि if the import export is either prohibited or regulated under any law, then that continues to be prohibited, regulated here also. But wherever for any item for which there is no regulation or no prohibition given, it means import and export of that article shall be free. Is that clear? Section 4 not required. Why it is not required? You can put across directly there. Right? कि अगर आपने मटेरियल प्रिंट किया तो उसको डायरेक्टली क्रॉस कर दो, उसके प्रिंट की जरूरत नहीं. This is all the orders made under the Import Export Control Order 1947 continue to be in force shall be deemed to have been made under this act. तो ये तब का था जब ये एक्ट एप्लीकेबल हुआ था. ये एक्ट कब आया था?
1992.
92, sir.
92.
So sometime even that it is also a question. 91, 92, 93, 94, now tick mark. Okay, so this is FTDRA 1992. So FTDRA is made in by replacing Import Export Control Act 1947. So any kind of order, etc., has been made under that order, which was already applicable at the time of